In this episode, we turn to a part of artificial intelligence, AI, governance that many beginners do not expect to matter as much as it does, the contract. By the time an organization is preparing to deploy an external AI system, people are often focused on model quality, business value, speed, and technical fit, while the legal agreement is treated like background paperwork that someone else will handle near the end. That is a mistake, because vendor contracts and licensing terms often decide who controls the data, who carries the risk, what the organization is actually allowed to do with the system, how fast support must arrive when something goes wrong, and what options exist if the relationship fails after deployment. A responsible organization therefore studies the contract before the system goes live, not after a problem appears, because the agreement is one of the places where governance becomes real, enforceable, and visible in language that can shape daily operations long after the excitement of selection and testing has faded. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyber.author.me in the Bare Metal Study Guide series. A helpful way to understand this topic is to think of the contract as the operational rulebook for the relationship between the organization and the vendor. The product demonstration may show what the tool can do. The sales conversation may describe how flexible and modern the system feels, and the technical review may reveal how it fits into the environment. But the contract is where the promises become obligations and the assumptions become formal terms. If the contract is weak, vague, or one-sided, the organization may discover too late that it has far less control than decision-makers thought they had when they approved the deployment. For a beginner, the key lesson is that buying access to an AI product is not the same as buying safety, accountability, or predictable support. Those things have to be built into the agreement, because if they are missing there, the organization may have little leverage later when service changes, prices rise, data questions emerge, or failures create pressure from customers, leadership, auditors, or regulators. One of the first things an organization should examine is the scope of the license itself, which means what rights the vendor is actually granting. A license can define who may use the system, for what purposes, in which locations, with what volume limits, and under what restrictions. Some licenses are broader than teams expect, but others are surprisingly narrow and may allow only internal use, limited user groups, specific geographic areas, or approved workflows that do not match how the organization really plans to operate. If those limits are not understood before deployment, the organization may build a workflow around a use case that the contract does not fully allow, which creates both legal and operational trouble. For a beginner, this is one of the clearest reasons licensing matters. The question is not simply whether the tool works. The question is whether the organization has legal permission to use it in the way it intends, at the scale it expects, and for the audiences it plans to serve once the system becomes part of real business activity. Licensing terms also shape flexibility over time, which matters because AI deployments often evolve after launch. A team may begin with a narrow internal pilot and then want to expand the tool to more users, more departments, or more complex workflows once early results look promising. If the license is rigid, expansion may trigger new fees, fresh negotiations, added restrictions, or even a need to redesign the deployment around terms that were not obvious at the beginning. The opposite problem can happen too, where leaders assume the system can be used broadly across the enterprise and later discover that the agreement was written only for a small group or a specific business function. Beginners should understand that governance is weaker when the license is treated like a technical detail instead of a strategic boundary. A strong review asks how the organization expects the deployment to grow, whether the contract can support that growth, and what hidden assumptions inside the licensing model could create operational friction or surprise costs after the system is already embedded in important work. Data rights are another central part of vendor contract review, and they often determine whether an AI deployment will remain governable in practice. The organization should understand what data the vendor receives, what the vendor can do with that data, how long it may keep that data, where it may store the data, who may access it, and whether the data may be used to improve the vendor's own models or services. Those questions matter because a deployment that looks attractive from a capability standpoint may become much less attractive if sensitive information is flowing into an arrangement that gives the vendor wide freedom to retain, analyze, or reuse that material. For a beginner, the important point is that data rights are not only about privacy in the narrow sense. They are about control, trust, and accountability. If the organization does not know exactly what happens to prompts, inputs, outputs, logs, and related usage information, then it may not really know what kind of relationship it is entering or what kinds of downstream exposure it is accepting. Closely connected to data rights is confidentiality, which should be reviewed with care rather than assumed. Many people hear that a system is enterprise-ready or secure and assume confidential data will automatically be protected in ways that fit the organization's risk profile. In reality, the contract may define confidentiality narrowly, include important carve-outs, or allow certain internal vendor uses that matter a great deal once the AI tool begins handling real business material. The organization should look at how confidential information is defined, what security expectations are attached to it, what exceptions apply, and what happens if that information is disclosed improperly through the service or by people supporting the service. For a beginner, this is a useful moment to see how governance and legal review work together. Strong confidentiality language does not guarantee perfection, but it creates clearer duties, better expectations, and stronger footing if the organization later needs to challenge weak handling, report an incident, or explain to others why it believed the deployment was acceptable under the circumstances. Intellectual property, IP, questions are equally important because AI deployments often involve uncertainty about ownership and usage rights around both inputs and outputs. An organization may ask whether it retains ownership of the content, data, prompts, and materials it provides to the system, but it should also ask what rights it receives in the outputs generated by the tool and whether similar outputs may be produced for others. In some relationships, the output may be usable but not exclusive. In others, the vendor may place limits on commercial use, redistribution, publication, or high-risk downstream reliance. The vendor may also ask for broad rights to usage data or derivative insights generated from customer interaction with the tool. For a beginner, the lesson is that IP review is not reserved for lawyers working in creative industries. It matters whenever an organization expects to rely on the outputs of an AI system in products, services, customer interactions, internal documents, or other material that carries business value and potential exposure if ownership or permitted use is less clear than leaders assumed. The contract should also be reviewed for warranties, disclaimers, and performance promises, because these sections reveal what the vendor is and is not standing behind. Many AI agreements contain broad disclaimers that say the service may produce inaccurate, incomplete, or unpredictable outputs, and that the customer remains responsible for reviewing results before relying on them. Some level of caution is understandable, especially with complex systems, but beginners should notice what those clauses really mean. They often shift much of the operational risk back to the deploying organization, even when the vendor's marketing language emphasized efficiency, quality, and innovation during the sales process. A good governance review therefore asks whether the promises in the contract match the confidence reflected in the business case. If the vendor is unwilling to commit to meaningful service quality, support responsiveness, or security duties, then the organization needs to ask whether it is comfortable carrying so much responsibility for a system it did not build and may not fully control. Service and support terms are another major part of the contract story, because once the system is deployed, the organization needs to know what happens if the vendor fails, the system degrades, or urgent help is required. Some agreements include clear response commitments, escalation paths, uptime expectations, and support windows. Others remain loose and leave the customer with very limited guaranteed help, especially outside standard business hours or for problems the vendor classifies narrowly. This matters because AI systems may be placed into workflows that feel routine until a breakdown affects customers, delays operations, or creates public exposure. For a beginner, the most useful question is simple. If this service starts harming important work tomorrow, what is the vendor obligated to do? How quickly must it act? and how clearly is that obligation written. A deployment becomes much harder to defend when support promises are vague, because the organization may find itself explaining critical reliance on a vendor that had no real duty to respond at the speed or depth the business situation demanded. Security obligations deserve close review as well, especially when the vendor will process business-sensitive, regulated, or customer-related information. The organization should understand what security controls the vendor commits to maintain, how incidents will be reported, what timelines apply to notification, whether subcontractors are involved, and what rights the customer has to receive information about security events affecting the service. It should also examine how access is managed, how logs are handled, and whether the vendor reserves flexibility to change its security practices without meaningful notice. For a beginner, this shows why contracts matter even in technical domains. Security is not only a feature of the system, it is also a set of duties in the relationship. If the agreement leaves incident notification unclear, limits the vendor's obligations sharply, or allows major unseen changes in the service environment, then the organization may not have the visibility or leverage it needs when security concerns become urgent after deployment. Change management is another overlooked issue, but it is especially important in AI because vendor services may evolve quickly. The vendor may update models, safety settings, retention practices, user features, or supporting infrastructure over time, and those changes can alter how the system behaves even if the customer has not changed its own workflow. A contract should therefore be reviewed for what notice the vendor must provide, what changes it can make unilaterally, what options the customer has if those changes affect risk or performance, and whether significant changes trigger a right to terminate or renegotiate. Beginners should understand that governance becomes fragile when organizations deploy an AI system based on one set of evaluated conditions while the vendor remains free to change those conditions materially in the background. A system that looked acceptable during review may become much harder to defend if its behavior, data handling, or control features shift later and the customer has little contractual ability to slow that process, obtain transparency, or exit without major disruption. Liability and indemnity provisions also deserve careful attention because they decide how losses and legal exposure may be shared if something goes wrong. The vendor may limit its liability sharply, exclude certain categories of damages, or refuse to take responsibility for harms tied to inaccurate outputs, misuse by the customer, or decisions made downstream from the service. Some agreements also address whether the vendor will defend the customer against certain third-party claims, such as allegations connected to intellectual property, while leaving many other categories of risk with the customer. For a beginner, these clauses matter because they reveal who is really carrying the burden when failures become expensive. If the organization is deploying the system into an important workflow while the vendor accepts very little real financial responsibility, that imbalance should be understood before launch rather than discovered during crisis response. Good governance does not require perfect risk transfer, but it does require leadership to understand what the contract says about who pays, who defends, and who stands behind the product under stress. Another area beginners often overlook is auditability and evidence. If the organization needs to review usage, investigate incidents, respond to regulatory inquiry, or prove that governance controls were followed, it may need access to logs, service records, support records, or other evidence held by the vendor. The contract should therefore be reviewed for what access exists, how long records are retained, what the customer can request, and whether the vendor allows any meaningful review of its practices beyond broad marketing statements. This does not always mean a traditional audit right in the strictest sense, but it does mean the organization should know whether it can obtain the information needed to govern the deployment responsibly. For a beginner, this is a powerful insight because many governance duties depend on evidence. If the vendor relationship leaves the organization unable to reconstruct what happened, when it happened, or what data and settings were involved, then incident response, compliance, and accountability all become much more difficult than leaders may realize during the excitement of adoption. Exit rights and transition planning are also critical because a strong deployment decision includes a realistic plan for what happens if the organization later needs to stop using the vendor. The contract should make clear how termination works, what notice is required, what happens to the customer's data at exit, what assistance is available during transition, and whether outputs, logs, or connected materials can be exported in usable form. Vendor lock-in can become a major governance problem when an organization builds important workflows around a service that is expensive to leave, technically hard to replace, or legally tangled in ways not understood at the beginning. Beginners should see exit planning as part of responsible entry. A mature organization does not wait for disappointment, price shock, or a serious incident before asking how it would unwind the relationship. It asks that question up front, because the quality of the exit terms often reveals how much practical control the customer truly has once the vendor becomes part of day-to-day operations. A simple example helps bring the topic together. Imagine an organization wants to deploy a vendor-provided AI assistant to help staff draft responses and summarize internal materials. The system performs well in trials, and the business team sees clear efficiency benefits. But a careful contract review may reveal that the vendor can retain prompts for service improvement, that output rights are broad but not exclusive, that support response times are weak, that major service changes require little notice, and that liability for harmful output is heavily disclaimed. Those terms do not automatically kill the deployment, but they change the governance conversation dramatically because leaders now understand the real relationship they are entering. For a beginner, the lesson is that contract review does not exist to ruin useful projects. It exists to expose the actual conditions under which the project will operate, so the organization can decide with open eyes whether the deployment is proportionate, controllable, and worth the obligations and risks attached to it. As we close, the most important idea is that evaluating vendor contracts and licensing terms is a core part of AI deployment readiness, not a side task left for the end. The contract defines the legal and operational boundaries of the relationship, while the license determines what the organization is actually allowed to do with the system and how flexibly it can grow later. Data rights, confidentiality, IP, support, security, change management, liability, evidence access, and exit terms all shape whether the deployment will remain governable once real work depends on the tool. For a new learner, this is one of the clearest places where abstract governance turns into practical control. A responsible organization does not ask only whether the AI system is capable. It also asks whether the agreement behind that system gives the organization enough clarity, leverage, protection, and freedom to deploy the tool in a way that remains defensible when the easy part of selection is over and the hard part of living with the vendor relationship has begun.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit DailyCyber.News.